Okay, so I'm going to get started. If you didn't know, we are being recorded, so the lawyer in me feels the need to warn everyone. My name is Janae. I am a staff attorney for Disability Rights Pennsylvania, and I'm going to talk to you a little about what that is and what we do. But welcome. I guess this is day 2 for you guys of your conference. So good for you guys for coming to a conference on a Saturday, right? So I'm going to jump into it, and I am very hands-on, so if you have a question, please feel free to stop me. You don't have to wait till the end, and we can take them at that time. So understanding your rights, your rights under the American Disability Act. I'm going to give a high-level overview of the American with Disabilities Act. Basically, what is it, who does it apply to, and when does it apply? And then I'm going to talk about some of the common legal issues that apply, that we run into, at least at our organization. And just a preview, it's inaccessibility with buildings, transportation, services from hospitals and healthcare providers, and employment discrimination. All of those kind of flow under the American Disabilities with Disabilities Act. So Disability Rights Pennsylvania, we are a nonprofit organization organized and created, I think it was 1950-ish, through an act of Congress to protect and ensure the rights of people with disabilities. There is a disability rights in every state. It's a federal legislation, so everyone has to have one. We have offices in Pittsburgh, Harrisburg, and Philadelphia. Other states might have one or two, depending on the size of the state. But it is our goal to ensure that people with disabilities have equity, treated equitably. We ensure civil rights. We provide technical training, kind of what I'm doing here. As far as the makeup of our staff, we're about half attorneys, but we also have advocates, outreach workers. We have a lot of people who work in our organizations to ensure that people's needs are being met. We have a intake line, and I have some information there about that, where us attorneys have to rotate. So it's like you'll talk to a live person Monday through Friday, 9 through 3, and you can, if you have any issues, we encourage people to call and ask questions. So we have a board, because we are a nonprofit, who sets our priorities and objectives. So this is just to give you an example: abuse, neglect. We have an investigation and monitoring team that will come out to different organizations if we suspect that someone's being treated unfairly. We do pop-ups at nursing homes a lot. We have the right to do that under the act, just to say, hey, we just want to talk to people, make sure they're being treated fairly, make sure there are no issues. We do that a lot. Our goal is that no one should be unfairly institutionalized. So you think about guardianships and things like that. We try to get people out of those and into a more or less restrictive situation. So we do a lot of litigation beyond that. We do special education cases. We do a lot at our organization. And this is just, we have different funding sources. So this is just the idea of what our programs fall under: people with developmental disabilities, mental illnesses, PABs, which is what I work under a lot, is people who are beneficiaries of Social Security who run into obstacles while trying to obtain employment, different things like that. These are just some of the programs that we work with. So if you are not familiar with us, I suggest you go to our website, disabilityrightspa.org, and kind of check it out and look at the different services that we may offer. Okay, any questions on DRP is what we call ourselves. All right, overview of the American Disabilities Act. So high level, the American with Disabilities Act is a civil rights law enacted in 1990. I think someone just reminded me it's our 35th year. This month is our 35th year anniversary, so for the ADA. And it prohibits discrimination against individuals with disabilities in many areas of public life. And when I think about that, right, 35 years is not a long time. So I can't imagine what it was like before that, right, before this law is here. So the purpose of the law is to make sure that people with disabilities have the same rights and opportunities as anyone who does not have a disability. And then there's a lot of amendments that came into play after 1990 that kind of specified more what should be done. And specifically in 2008, the ADAAA, which defines what a disability is, and high level, we'll talk about that. So a disability is considered any physical or mental impairment that substantially limits your major life activities. One must have a record of having this impairment and be regarded as having this impairment. So that's just legal jargon to say someone must know, even though a lot of disabilities are hidden, so you don't have to disclose, but if it came to a claim under the ADA, you would have to disclose what it was. But as far as interfering or limiting life activities, here's a small list of what that means. Just anything that interrupts caring for yourself, walking, standing, seeing, hearing. There are some disabilities that are automatically considered a disability under the Act, such as blindness, hard of hearing, deafness, but there are others that they have to kind of go into deeper detail about. So that is the who it applies to. When does the ADA apply? Again, it's a federal law, so it's across the United States. It prohibits discrimination for people with disabilities in employment. Your state and local government can't discriminate against you. Any public accommodations, such as this hotel, telecommunications, telephone and internet providers cannot provide discriminatory service. And then there's Title V, which is kind of a catch-all and adds things that are not considered to be disabilities. So, as I said, we're going to talk about some of the ones that I deal with on a daily basis, that some of our most common questions that are brought to us. Inaccessible buildings, transportation, inequitable services, and employment discrimination. Now, I'm going to talk about examples of each and what my suggestion is if you encounter a situation like that. And we're going to talk about a lot of what we do at DRP is teach self-advocacy. So like, what can you do on your own to help the situation? Okay. Inaccessible buildings falls under Title 2 and 3 actually, depending on what the building is. An example would be older buildings that have narrow hallways where someone in a wheelchair can't access it, or they have about 5 floors and no elevator. Things like that would be discriminatory under Title III of the ADA. So that, and it would cover any public or commercial facility. This would be considered a public facility, right, because it's a hotel and they're inviting people in. A commercial facility would be your office buildings, your doctor's offices. All of those buildings are under the umbrella of the ADA, so they have to be accessible. So a lot of times, go ahead.
Can I ask you a question?
Yep.
So would that mean like a public university versus a private university? You would be covered under the ADA if you went to a public university?
Public and a private, because a public would fall under public and a private will fall under commercial.
It would still be considered commercial?
Yep,
Okay.
because it's open and they invite people in
Okay.
for services. So either or you're covered in a university. There's things that they have to have, like elevators, curb ramps, different things like that. Parking.
Automatic doors, like the buttons for doors, does that fall under that?
So, let me see. So it goes down to construction. That's the thing about this section of it. A newer building, which is newer is considered after 1992, they would have to have accessibility. They would have to have the push buttons if they have automatic doors. Now, if they don't have automatic, you can't make them have automatic doors, right? So if it has automatic doors, a newer building should have the push button, but an older building might fall under the exemption. So it depends on when the building was built.
Okay. So I was fighting with my son's school, because he can't physically open some of the doors.
Yeah.
And so I'm like, well, how does he get to things? I'm like, oh, we just open it for him.
Yeah, it depends on when the building was built. And then if it's an older building, even if it was built before 1992, if they've done any major renovation, then they have to fall under the newer guidelines. So it comes down to when the building was built. So a newer building has to have all of the new requirements. They have to have an elevator if there's more than three stories or more, or if it's a shopping center, a professional office, a healthcare provider, or a transportation depot, i.e. an airport, a bus station. They have to have elevators and the doors that open automatically. And again, if they were built before 92, technically they don't have to meet the standard, but if they've done any renovation, they do. So 9 times out of 10, if a building was built before 92, they've done some sort of renovation. So if it's an existing commercial facility, so commercial facilities such as, like you're saying, the school, they don't have to make the door automatic unless they have remodeled, and I'm sure they have remodeled. So there is an exception if there was a employee who was in a wheelchair who couldn't get through the doors, then they can ask for a reasonable accommodation or a reasonable modification under Title I, but we'll get there.
I found this like the public schools though, what they'll say is if they have an equivalent school in district that has that door, that they will say that your child can go to that other school. So they don't have to change every school in district
Right,
to meet to meet that.
Yeah.
What they have to do is have one school available that has that for your child within their district.
but then if I were in that situation as a parent, I would call someone like us, because we would argue that why does my child have to go an hour away to school, right, when you can just add this modification? So I think in situations like that is when you would call an advocate or an attorney to kind of help, which leads to this one. So what can you do if you are in an accommodation and you feel that it doesn't meet the code or has somehow not met the ADA requirement? So my first suggestion is always go to the owner of the building and try to informally resolve it. Say, hey, we need a push button, or hey, you don't have any accessible parking spaces. Can you fix that, right? And if they're unwilling, if that doesn't work, or get the resolution that you're looking for, the next step up would be your local township or your local government authority, because there are always local rules that even go further than the ADA about what a building should or should not have. So you would go to your local government authority and ask them and tell them that you want to file a complaint about this particular building because it's not meeting the code. So think code enforcement. So that's your second level. If you get nowhere there, the next level would be in Pennsylvania would be the Pennsylvania Human Relations Commission. If you're in another state, I'm sure they have an equivalent for your state. Now the PHRC is pretty good in Pennsylvania. Lately, I've been getting a lot of relief from them. But if for some reason that doesn't work, the next level would be filing a complaint with the United States Department of Justice, which often takes time. You're probably going to wait a year with the new administration and all the changes. Who knows what's going on there, so maybe more. And if all else fails, the next step would be to file a lawsuit about the inaccessibility. Under Title II, there's no recovery for damages, but you can get an injunction. You are able to, if you win, successfully remove the obstacle. But at any point, you can call us or our equivalent agency in a different state for, even with step one, talking to your building owner, right? You can call an organization like us, and we were happy to advocate on someone's behalf. Any questions about buildings before I?
And my question would be, if I didn't get a response from Arizona, can I call you in Pennsylvania and be like, do you have any advice on this situation?
We would send you to our Arizona DRP, which Disability Rights, which has a really good one. We often go down there for our conferences, so I've met people from down there, so we would kind of do the handoff to Arizona.
Say something about that, from
Sure.
being burnt in the past. I'm really neurotic about getting everything in writing. So like
Yes.
when I, so I keep Google Doc and everything, but I keep the date and the time, the name of the person I spoke to, and then when I'm ending it with them, I ask them for their email address, and then I'll send out an email and I'll say, gee, thank you today, Marcy, for spending the time with me. I just like to recap our conversation today, and boom, I put it all in writing.
Yes, and that's helpful for an attorney as well, because a lot of times people are calling us and it's all verbal conversations. I'm like, do you have any emails? Do you have anything in writing that says, hey, I tried to get this fixed. I tried to get accessible space. They told me no, because a lot of times they will try to do it verbally, right? So they leave no paper trail. So I agree. Document, document, document everything. So inaccessible transportation. This falls under Title II of the American with Disabilities Act. It applies to all public transportation services such as buses, subways, airlines, even though they have their own act too, but it applies to airlines. It also applies to public and private entities that provide public transportation, taxis, ride shares, Uber, Lyft, shuttles. Anybody that provides transportation to the public is subject to the American Disability Act and cannot discriminate against a person with disabilities. Basic requirements include they have to have, and this is important, accessible paths of travel. Actually, a case here some years ago was that from the parking lot where one would park their car and to where they would enter the building was not accessible to someone in a wheelchair. So the airport had to create an accessible path straightforward where someone with a wheelchair, whether it's curb cuts or something like that, would have the ability to get from their car to the building without ducking cars and things like that. Ramps, bridge plates, there has to be bus stops and shelters for people, curb ramps, elevators. If you're on a bus or a shuttle, you have to have adequate time to be able to get on. I'm honestly working on a case right now, it just blows my mind, where a local bus driver refused to lower the ramp for a person with a wheelchair, and then one time lifted it up and the person got caught in the door. Just all sorts of horror stories happen. I don't know if they were in a hurry, I don't know, but that happened. So that's obviously a violation of the ADA, but that's an example. There has to be priority seating given. A biggie, another case that I've worked on recently is service animals with Uber and Lyft. A lot of people say that they order Uber or Lyft, the driver pulls up, sees that they have a service animal and pulls off. Happens a lot all over the country. There's been a lot of lawsuits filed against Uber and Lyft. The problem is Uber and Lyft don't consider themselves to be, because their drivers are contractors, right? They're not an employer. They call themselves software because it's an app, and it's hard for someone to legally sue them. But we have been successful in getting awards to our clients, but they are still subject to the ADA. They are not allowed to do that. They can't say, oh, a dog, and leave, right? They're not allowed to do that. So we have been successful with working the issue out. So, but that's a biggie all over the country.
Quick question,
Yep.
what defines a service animal?
So service animals is probably a whole other, speech, but it's medical documentation. That's what it comes down to. There's a difference between an emotional support animal and a service animal. A service animal you have to be able to medically document that it somehow assists you with your disability. It can be something as simple as supporting you if it looks like you're anxious, right? that can, if you have a disorder like PTSD, the dog sees you getting anxious and is able to calm you, and your doctor can document that, that is a service animal. An emotional support animal would just be a person who has anxiety or phobia, but doesn't necessarily have PTSD, who needs the animal for emotional support. It all comes down to medical documentation, is the difference between the two.
Does that differ when it comes to, say, animals going into restaurants or getting onto vehicles or into vehicles?
Yes. No public entity has to allow an emotional support animal. They all have to allow a service animal. So that is the big difference. The only person that's obligated to allow you to have your emotional support animal is your landlord. They can't deny, they can't charge you a pet fee for it. But a public entity like a restaurant, a bus, airplane, Uber, they do not have to allow emotional support animals, which is why you'll often hear the question, what does your animal do to support your disability? That is their check question in restaurants and stuff, because that is a difference between the two.
But a service animal too will usually have some sort of, like has like a vest and like, because they have to go through training, so they have like a little card and like a certificate, and they'll usually be wearing something that specifies them as a service animal versus an emotional. I think anyone can just like fill out a form for an emotional support.
Yeah, but I mean, some people don't know the difference, right? A person working, an Uber driver might not know the difference between what that certificate says. It might be saying emotional support or service animal, but they might not be able to readily see the difference. But should it come down to a complaint, the documentation will have to come from a doctor saying that that animal supports your disability.
And is this federal or state specific?
Federal? Yep,
Because North Carolina is a little different.
really?
My daughter worked in restaurant, and they were told not to say anything to anyone who came in with an animal. There was no vest, there was no certificate, there was nothing. They were not to say anything unless the animal was causing and creating a disturbance in the restaurant.
Interesting.
Like, going after other people, or if there was another animal, they were, trying to fight that animal.
Really?
Then they could exit,
No, so they were just adding, I guess, more protections, which is good. I mean, good, depending on what the situation, but they were adding more protections, but federally, they are allowed to ask, what does this animal, is this an emotional support or a service animal, and how does this animal support your disability? Those are the two questions that you are allowed to ask in a restaurant or any public entity. Yep. So if you're in a situation where you feel as if a transportation provider did not honor your rights under the ADA, again, I say you start with the agency or the entity, Uber, Lyft, or your transportation agency. And a lot of times what we have to do is, what I do a lot is write letters to different organizations and say, hey, my client visited your restaurant and was denied service. Consider this letter a formal request for a reasonable accommodation for the service animal. Should you have any questions, give us a call because you're in violation of their ADA rights. So a lot of times that resolves the issue, just asking for formal, reasonable accommodation with the agency, with the entity, the restaurant, whatever. If that doesn't get it, next step would be your state agency, your Human Relations Commission, found a complaint. Again, I've had success there at that level in a relatively short amount of time, where we were able to meet with the agency owner, ensure that this won't happen anymore, and sometimes we were able to secure settlements for damages for our clients. If that doesn't work, next step, Department of Justice. Good luck with that. The next step, and what I would probably do it in 2025, today I would say, if that doesn't work, I would go to the lawsuit. Found a complaint with the Federal Transit Authority, or if it depends on what the entity is. If it's the airlines, it's a different entity, but same, say the FAA instead of the FTA. But you have to file a complaint, and this is where it gets important. There is a time limit here, within 180 days of the alleged incident. And then after that, you can file a discrimination lawsuit, and then you are able to get damages, and you just have to kind of show your proof of your damages. Go ahead.
So other than the discrimination lawsuit, are you required, or is it necessary to spend the money to hire a lawyer to do these things?
To
I
do,
mean, obviously,
no.
you're working with the state agency, you're the lawyer working for the state agency, you can help me?
Yeah,
Right.
you don't need a lawyer, you don't need a lawyer for any of the steps aside from the lawsuit, right? So to file a complaint with the organization, you can do that on your own. You can, and you can go online and get examples of reasonable accommodation letters about what you should say.
Yeah.
You can file the complaint with your state agency or the Department of Justice. You can do it online. It's about a few pages. You can do all, in fact, I would advise to do all those things. Don't hire an attorney to do those things for you unless you're just fed up with the whole situation, which is understandable. And again, like an organization like ours would do it free of free of
Yeah.
charge, but
Okay.
you don't need us. And for the complaint, with the state, the DOJ, or even with the transit authority, you don't need an attorney. The only time you would need an attorney is in court, and oftentimes they may appoint one. Go ahead.
I just want to say, my husband is head of security for our regional transportation bus authority.
Okay.
And so what I would tell people is the minute you have that problem, you call, because there are 8 high-definition cameras on their buses.
Oh,
And so he's had issues happen that his bus drivers didn't do what they were supposed to do.
right.
And so they made it right for the passenger
Yeah.
and took corrective action.
Which is amazing, yeah. I mean,
So they're not against you, but
no.
the video recordings they only last in the system for so long.
Right, and that's the thing.
Because then your proof is gone.
Right.
You're gonna reach right out.
Yeah, and that's the thing, to do it right away. Any questions about transportation? All right. So another biggie is inequitable access to healthcare or any type of provider services. There are a number of agencies that oversee healthcare providers. The CMS, that's for Medicare and Medicaid, Joint Commission, they accredited most hospital and healthcare providers, and in Pennsylvania, the Department of Health. So those are the agencies that oversee doctors and hospitals. They have created a Bill of Rights for patients that everyone, high level, is entitled to participation, to be treated with dignity and respect, not to feel discriminated against. And a lot of times, we get a lot of complaints about the treatment, whether it's in the ER, whether it's in a doctor's office, just about not feeling like they have or treated fairly by their doctors and not being able to speak about it because you're scared because you're there for a reason, right? So that's when a lot of people come to us and we can advocate on their behalf. So again, there's a hierarchy that I found to be successful about what to do when you feel like a hospital or you've been treated unfairly by a healthcare provider. And it's always, again, try to solve the immediate problem by going to a nurse manager, a supervisor, a hospital patient representative, higher level if you don't get there. It's the supervisor, the CEO of the hospital, all of those people to solve an immediate program. A lot of times, we get it from family members who, for whatever reason, their family members unable to speak on their own when they feel like they're not being given a voice in the situation. So in that situation, we can help advocate and take it to the immediate to try to solve the immediate problem. That doesn't work, grievance or complaint with the hospital or the healthcare provider. And then if all of those don't work, that's when you get to the agencies that oversee them, the state agency. If it's a Medicare insurance issue, we get a lot of those, right? Medical insurance providers not wanting to pay for services. You might need a different size walker, a different size wheelchair our agency and other agencies will help advocate by requesting a hearing, filing a grievance with your insurer. We have had several over the years that precede me at our organization. We have had several class action litigations against our state Medicare or Medicaid programs for not doing what they're supposed to do as far as providing services. So the main thing you could take away from that is that there is help everywhere of people who oversee, and not to be afraid to file the complaint. And then there's the corporate headquarters, local news media, but at any point you can contact us or any attorney that specializes in healthcare issues. Go ahead.
Yeah, maybe I'm jumping ahead, but can you talk about the process of how to deal with problems with commercial insurance? Because certainly there's a lot in the news about, for example, United Healthcare is getting, investigated by the federal government because of their Medicare Advantage program problems. Can you talk about the process of like insurance company, let's say, denies a particular medication you might need or a particular care you need, and kind of what the steps are when it's a commercial insurance company that's denying care?
Oh, and you're saying in opposed to Medicare or a Medicaid type agency. It's,
Opposed to being the hospital or medical provider, it's the insurance companies themselves that are kind of
yeah.
care.
Yep, it's kind of the same steps, right? I would start with in Pennsylvania, the Department of Health, because they still oversee any medical insurer in the state, whether it's Medicare, Medicaid, or any private insurer. Most insurers have a complaint process, right? You file an appeal if they don't provide enough nursing hours or they're denying service. So you start with that informal grievance process. You still have the same rights. You have a right, if that doesn't work, to what they call a fair hearing, where they put you in front of, sometimes it's the board of doctors that work for them, but still there's some sort of informal appeal process, right? You go through that, and then if none of that works, then instead of the Medicare, you would contact the Joint Commission, right, and say, they're discriminating against me, Department of Justice, there's the Office of Civil Rights, different federal agencies that say, I've did everything I could possibly do, they're still denying me service, I went through every step, and then comes the lawsuit. But there are different agencies. I would go through the informal process with your insurer, your state agency, because ultimately your state has the most control over these, if they're doing business in their state. Then you would go to the federal, the Department of Justice, and then at that point you might as well just go ahead and file a lawsuit, right? Even sometimes just filing the lawsuit or having an attorney contact your insurer straightens them up. Getting a letter, we do a lot of what we call strongly worded letters, saying, hey, you're violating our client's rights. If you don't answer to us within within 30 days about whether or not you plan to correct the situation, we will file suit, and that usually does it. So it just depends on the situation, but it's still the same process. You just take out the Medicare, Medicaid oversight. Did you have a question? Okay. All right. Employment discrimination, also a biggie. In addition to the American with Disability Act, there are other acts that prohibit employment discrimination. There is the Rehabilitation Act, which prohibits against federal or government entity workers, and then in Pennsylvania, there's the Pennsylvania Human Relations Act. They all do the same things, but depending on what you do or where you're employed, different acts cover you. Ultimately, what they all do is provide protections against discrimination in any part of the job process, the application, the hiring, benefits, advancement, training, any terms, condition, or privileges of employment. If you need accommodation, reasonable accommodations to successfully do your job, and there are certain medical exams that an employer cannot require. But those three laws cover any discrimination that happens in the job working process. Okay, the ADA protects a qualified employee from being discriminated against because of their disability. So if I had a disability that prevented me from working, let's just say I had a learning disability, and I wanted to work at Starbucks. Although I am an attorney and have been an attorney for over 20 years, I can assure you that I have no skill set that would be successful at Starbucks. So I would not be considered an employee that is qualified. So if I'm discriminated against, I can't say, if I go in there, I want to say, I need you to train me an additional 1,500 hours to even know what to do with this machine, right? Like, that's a lot. I can't ask for that as a reasonable accommodation because I'm not otherwise qualified to be a Starbucks barista. But if an employee is qualified and then is ultimately discriminated against, that's when the ADA and other protections come in. And we will talk about,
Can I ask a question?
Yep.
So like, if you're in a wheelchair and you apply for a job as a roofer, and the job requires you to climb up onto the roof,
right,
you're not qualified.
you're
So
not,
it's not discrimination that you're not hired because you're not qualified.
right, that's different.
So it's all about what,
So, but there's certain, so I'm a nurse,
Okay,
okay, and there was the American College of Nursing made some woman, I'm trying to find her right now, 1996, 99, I can't remember the year. She created these guidelines of what you needed to be able to do to perform your duty as a nurse.
mm-hmm,
Okay, so one of them on there was be able to hear properly.
Mhm.
Well, that's outdated,
Sure.
because now we have stethoscopes that can do that for us,
okay,
right?
yeah,
yeah,
So, that's something I want to change, and infuriates me, because you have someone who's knowledgeable, skilled, they can do all of that, but they can't hear.
yeah, so they would need an
But
accommodation,
where
sure.
that causes a hiccup is, that document that was made for employment is what the colleges are using for you to get into nursing school.
ah,
So these students may not be eligible
yeah,
to go to the program. See what I'm
Yeah.
saying?
yeah,
So to me, that's a slippery little slope.
Yeah, but I think if I was a student who had a hearing disability and I wanted to be a nurse and that was my obstacle, I would challenge it, right? I would bring a suit. I would do all the things that we'll talk about you can do. I would challenge it with the college and say, this does not even fit under the ADA. Like, you can't do this.
Right, because like tractor trailer drivers, like you have to do a CDL license, and you have to be able to see color,
yeah,
right? So a lot of them now, it's changed, there's glasses now that they can wear, where they
Yeah.
can see color.
Right.
yeah,
So to me, that's outdated.
Yeah,
yeah.
which it is. And if they had an issue, if they were denied employment
Right.
because they're colorblind,
Right.
again, I would challenge it. And if I was that person, I would bring suit.
It's hard to know what's challengeable and what's not. So for instance, my daughter's in vet school, and I'm worried because if you look at the requirements for getting the doctor of veterinary medicine, it clearly states that you're expected to lift 50 pounds over your head.
Right.
And she could flip a sheep during one of her courses, and she's trying to build up the strength. She can now do 35 pounds. But, you know, God forbid she spends all this money and time in vet school and then doesn't get certified.
Right, that's my point.
And it's like scary to me that like, you know, she's just so gung ho and God forbid. Now with anesthesia now, with a lot of these large animals, it's not as critical as it used to be because of the type of drugs they can use on these animals and stuff.
But aren't they able, but can't you do the same thing you can do with people, right? Aren't there tools or different things you can do to move the animal around the same?
Equipment to
Yeah.
lift patients now.
Yeah.
Some of our patients are 800 pounds,
Yeah.
you know what I mean?
I do, I'm just telling you, if you look at
Yeah,
the.
outdated
if
policies,
you look
the
at
wording,
policy,
yeah,
It says you have to lift 50 pounds over your head.
yeah.
So me, I'm going back, in my nursing, you know, because I don't fight enough of shit in my life,
Yeah.
you know, I'm gonna change that. So I'm moving back to the original, where that came from.
Yeah,
what
that's a good idea.
Yeah.
changed.
So it's up to the people who work in policy, who work there, to change the internal policies, but because they're outdated and because they violate the ADA.
Well, I think it kind of goes to this also, which is the idea of whole reasonable accommodation thing. And I think that, you know, this is where I think people with legal knowledge come into it because, you know, the reasonable accommodation, I assume,
Mhm.
This is not information that patients would typically have, or, or people with affliction would certainly have.
Yeah.
Like, what has been approved?
Right.
What accommodations have they said is reasonable,
Yeah.
Can the school be required to provide somebody to help lift the sheep?
Yeah.
Is that a reasonable accommodation, or is that not a reasonable accommodation?
I would say it is, and we'll talk about why. So, what is a reasonable accommodation? And a reasonable accommodation is what an employer must do if an employee is otherwise qualified for the position, they must make any modifications or adjustments to the work environment so that this person with disabilities can adequately perform their job. So this is the legal language that enable a qualified individual with a disability to perform the essential functions of that position or enjoy the equal benefits and privileges of employment. That is what an employer must do under the ADA as a reasonable accommodations. So, and again, with time, this has evolved and changed, like you said, with cases, situations. Assigning, here are some examples. These are just common examples that come in our door a lot, or we know the cases of. Assigning tasks orally instead of writing, or writing instead of orally, because if someone has a learning disability and it's better for them to see it in writing, or it's better for them to hear it. Making the workplace accessible. Like I said, about having automatic doors, closer parking spaces, those are examples under that. So restructuring a job to eliminate marginal tasks. An example would be someone, maybe they work at a college and they're a teacher assistant, and they're not, because they have a different disability, they're not good with small things like copying and different jobs like that because it triggers their disability. And then a supervisor is required to kind of go through the interactive process, see what that employee needs to be able for them to function fully and well in their position, allowing more breaks, modifying the work schedule, scent-free policies, allowing leave so someone can go to the doctor early or late, and modifying equipment, screen readers. We get that a lot. A lot of people need different things to help during meetings because, again, you might not remember everything, but if you're allowed to record it and take notes that way, you can be more effective. So readers, if all else doesn't work and a person is otherwise qualified, but what they're doing is not, they can't do it because of their disability, you do have an obligation sometimes to reassign them to a vacant position if one's available. Job coaches, service animals, telework, different things like that. I'm sure in your lives, you guys have encountered situations where people needed different modifications in order to successfully achieve their goals.
So I'm just wondering, when you're applying for a position and you need one of these accommodations and it's known during the application process, how can you tell, or like how do you tell if the employer chooses not to hire you because they don't want to make the accommodations?
So when you are applying for a position, if you are otherwise qualified for the position, you do not have to disclose during the application process that you need a reasonable accommodation. If you may need a job coach or you may need to have longer breaks or whatever, you don't have to disclose that during the hiring process if you're otherwise qualified for the position. Once you're hired, then that's different. If you're unable to, once you've hired and gone through the training period and you know that you need more time for this or that, that's when you start that triggers your request for a reasonable accommodation. That triggers the interactive process with your employer. Your employer is saying, what do you need? How can we accomplish it? What do we need to do? So it wasn't during the hiring, it's after you're hired.
Yes, and I mean, I'm sure a lot of us have this with our kids, like, if my son walks into a room, like, you can visibly tell that there's going to need to be
Sure.
accommodations. And so I just worry, like, because the job market's tough, like, people don't get jobs just because there's too many applicants, but at what point are we looking at, like, there could potentially be, like,
I think it'll be hard unless it's blatant. Go ahead.
On the flip side of that, I work in environmental health and safety in the insurance, on the brokerage side. And we talk to our clients about hiring the right person for the job because we've seen people that have 25-pound lifting restriction, 15-pound lifting restriction, for the rest, permanent restrictions, and they'll apply for a job where the qualifications say you'll need to lift 50, 75 pounds, and they'll apply for it anyway. So what we're doing now is saying, hey, review the job description, the physical job descriptions with the applicant and ask them, at that point, are there any reasonable accommodations that need to be made? That's what we're counseling because we don't want to hire somebody into a position, granted, they're not being truthful with us. So we're trying to do what we can to make sure that we don't put somebody in harm's way by putting someone with a 15-pound lifting restriction into a position where they have to lift 50 to 75 pounds. Because they'll lie to us.
Well, this is a tricky thing, because again,
Yeah.
they don't have to.
They don't have to disclose, yeah.
Medical issues in the hiring process.
Nope.
But I understand what you're saying, is that if your job is to, break boulders apart every single day with a jackhammer,
Yeah.
and you don't have enough strength to lift the jackhammer, how are you gonna be able to do the job?
So what would you do? I mean, is there a medical examination that you would give someone after they get past the initial?
If it's a heavy labor's position or a company that has a physical labor's type of job, then a lot of companies will send them off to a physician to do a medical qualification.
Yep, I think that's where you're going to find out. You don't have to disclose needing an accommodation in the interview process, because if you're otherwise qualified, right, nothing else prevents you from doing the job, then you don't have to disclose it. But I think where it gets weeded out, I think, is in the medical screening. As long as you're giving everyone a medical screening, not someone who looks like they can't do it, as long as everyone is getting it, it's okay.
Now, related to that, so the other side of this coin is that if you're a parent, or a spouse of someone with a condition, I mean, I was in that position where I was hired for a job. I didn't tell them, well, my son, my wife might require me, let's say, to have time off to help get to a doctor's appointment.
Sure.
Or to, to deal with something particular happening in school, whatever it might be.
Mm-hmm.
And I remember one point my employer said to me, which was probably illegal, but they said it anyway. They said, if we'd known you had all these issues going on, we wouldn't have hired you.
That's awful. Yeah, that,
Again, it's kind of.
it's reality, right? It's reality.
But that's beside the point.
Yeah.
The question is that, is there anything in the law that covers the caregivers of someone
Yeah.
has
that's a good question.
needs?
Yeah, I think at that point you can, it's FMLA, right, family medical leave, and there are restrictions under that, but that is one way. Depending on your employer, they may have short-term leave where they let you take leave periodically for different issues. But I think that's something that can be discussed once you're hired and with your HR.
Because my employer was too small,
Yeah.
and actually covered by FMLA.
Yeah, I think it would come down to your leave policy at your employer, what their leave policy is. And if they were blatantly enough to say, we're firing you because you are taking off to care for your wife, you would have a cause of action under the ADA to file a complaint with your EEOC, which I'll talk about this real quick. So there are situations where an employer does not have to provide an accommodation, and that's if it would be an undue hardship to the employer. There's a lot of controversy around that. A direct threat to the health and safety of others, or it's unreasonable. So that's when it becomes a case-by-case situation, right? So that's when the law has to come in and decide whether or not the accommodation is reasonable or not. Here's an example. It will require the employer to reallocate the essential job functions, which goes to your question. If you have someone in a wheelchair who wants to be a roofer and they can't physically climb on the roof, an employer is not required to make some other sort of job function for a roofer, right? That's an undue hardship. If the accommodation would leave an employee unqualified, they don't have to lower production standards, require the employer to provide personal use items. You can't make an employer buy your car if that's not part of your benefits because you have mobility issues, or you can't hate your supervisor and decide that your reasonable accommodation is that you like Joe better. Things like that are considered unreasonable. And should you find yourself or someone you love in a situation, the big thing to remember is that there is a time frame issue with filing a complaint. And the difference between all the other things we talked about in employment is that you have to file a complaint with the EEOC or the state equivalent, either within 300 days of when it happened or 180 days state. In order to later file a lawsuit, you have to exhaust your administrative remedies. So you have to go through the EEOC when you feel you've been discriminated against and you might want to file a lawsuit later. You have to go through that process. You don't need a lawyer. Literally, it's about 3 sentences online. I'm discriminated against. This is where I work. Here's my contact information. It then takes about now I think they're saying 3 to 6 months, you'll get an interview from the EEOC. Again, that'll be on either virtual or on the phone. They'll ask you what happened. At that point, they'll send something to your employer saying, hey, these are the charges against you. How do you want to resolve it? They offer mediation sometimes, which we always tell people to take because it doesn't hurt. You may be able to resolve it. None of that works. There's an investigation. They find that your employer was or was not discriminatory. You then get your right to sue, and that's when you can actually file a lawsuit. But you have to go through those steps in order to do so. So different things. If you have at least 15 employees, then it's EEOC. If it's less than 15 employees and you're in Pennsylvania, you have to file it through your state agency. Both have online, both have time constraints about when and how to file, so we were running a short time. But just, again, it's all about self-advocacy. You guys are a really smart group. You're very self-aware. You know what you need, how to advocate for yourself. You know, utilize your support systems to help you. And on our website, we have a lot of pamphlets and resources that talk about everything that I just talked about with you in more detail. And we have it on all sorts of subjects to help kind of set the framework for should you want to advocate for yourself. Like this is just a snapshot of what all the different publications that we have on our website. So here is our intake line, 1-800-692-7443. And you can do an email to us with a question. Either way, it gets assigned to us. And again, our intake line is staffed live 9 to 3 every day except Monday through Friday, every day except Wednesday. So you'll talk to a live person. 9 times out of 10, it will be an attorney. And you can ask your questions right then and there. Thank you. And it's 3:01, so good timing. But no, I have cards here too if you guys want one. Feel free to contact us anytime for any questions.